The H1B guy here, and today here are the headlines impacting immigration benefits in the US for week ending July 17th of 2020. On July 14th of 2020, an article was written for Yahoo Life by R.T. Swaminathan titled Trump Administration Reverses New Visa Guidelines for International Students. The introduction of the article is quoted below. Quote, the Trump administration walked back a sudden policy change that would have potentially blocked hundreds of thousands of international students from remaining in or returning to the U.S. while pressuring universities to resume in-person classes in the fall amid the ongoing coronavirus pandemic. Following a week-long fight by Harvard University, the Massachusetts Institute of Technology, and more than a dozen state attorney generals, the government agreed on Tuesday to rescind a policy that would have affected international students who are attending institutions that have opted to go completely remote over the fall. The article then addresses ICE's new guidance, covers whether the initial ruling was actually illegal, and discusses the struggles academic institutions have been undergoing both pre- and post-pandemic. One important note not mentioned in the article is that ICE is stating that if international students have not arrived in the U.S., they should remain in their home country. Check out the complete post from Wednesday covering the administration's pivot on the F1 guidance issued to ICE and a review of the number of international students in the U.S. from 2008 on the H1BGuy.com, or watch the video on YouTube, both titled Pivoting on F1 Guidance to ICE. On July 15th of 2020, in an article written for Forbes by Stuart Anderson titled Major Lawsuit to Save Families from Trump H1B Visa Ban, an overview of the key text below is quoted under full quotation. A new lawsuit hopes to save H-1B visa holders and their spouses and children who the Trump administration will not grant visas or allow to enter the United States. Filed on behalf of 174 Indian nationals, including 7 minor children, the legal action, the first to challenge the recent presidential proclamation, asked a court to compel the State Department to issue decisions on the plaintiff's pending request for H-1B and H-4 visas, to enjoin the Department of Homeland Security from refusing entry to the United States, and to declare unlawful the proclamation's restriction on issuing new H-1B or H-4 visas or admitting new H-1B or H-4 visas. The complaint filed in U.S. District Court for the District of Columbia points out that Congress specified the rules under which the H-1B visa holders could work in the United States and balance the interests of the U.S. workers and employers. An employer is required to pay an H-1B visa holder the higher of the prevailing wage or the actual wage the employer pays similar employees, to post a notice when an H-1B professional is at a work site and commits to other obligations, note the plaintiffs. The complaint seeks to protect H-1B professionals, including those who have passed the labor certification process and possessed approved immigrant petitions. Such individuals are waiting for their priority date to obtain permanent residence, a wait that can take many years for Indian nationals. The statute requires employers to obtain a certification from the Department of Labor stating that there are no qualified, able, and willing United States workers available to fill the employer's job opportunity, according to the complaint. To get a labor certification, DOL's current regulations require an employer to engage in good faith effort to recruit United States workers before obtaining certification, including advertising the position and demonstrating that the job opportunity is clearly open to any qualified United States workers. The complaint also notes that Congress sought to increase employers' continuous access to specialty occupation workers from countries with long waits for immigrant visas under the American Competitiveness in the 21st Century Act, AC 21, which was passed in 2000. In light of the long backlogs for immigrant visas based on the AC 21 extensions, it is common for nationals of certain countries to be in H-1B visa status for years. According to plaintiffs, as such, longtime U.S. residents, often with U.S. citizen children, must go to their home consulate when they travel internationally if they do not have a current visa. The causes of action in the complaint include the proclamation's suspension of the entry of foreign nationals returning to the United States to resume employment under approved H-1B petitions constitutes an ultra vires attempt to regulate the domestic economy and subverts Congress's careful balance of interests reflected in the text. The complaint adds the proclamation also violates the Administrative Procedure Act, since the proclamation was issued outside the jurisdictional limitations of the INA, Immigration and Nationality Act. The third cause of action states that the proclamation is unlawful because under the APA, the executive may not withdraw, suspend, revoke, or annul a license unless it gives notice and provides an opportunity to comment. USCIS's granting of a petition to a classifying a foreign national as an H-1B non-immigrant or an H-4 non-immigrant constitutes the granting of a license within the meaning of the APA. There is really a lot to unpack here in this article. As the article alluded to at the very end, this is only the beginning of the lawsuits around the presidential proclamations going forward. The decision to state cause enacting the APA is an intriguing approach, specifically with the issuance of the licensing argument. There's also been a lot of debate on Senate Bill 386 and the green card backlog specifically for Indian nationals. Look for more from the H1B Guy covering S386 next week. There's no doubt the entire immigration benefits and intent conversation are very polarized and controversial topics. July 15, 2020, an article that was published on MarketWatch and was written by Harry Wren titled, Canada's appeal to tech startups grows in a wake of Trump suspending H-1B visas. The article starts off by stating that more U.S. tech startups operations are likely to expand to Canada as the Trump administration's recent restrictions on H-1B visas compound the difficulty of hiring skilled engineers, the venture capitalists and entrepreneurs say. It mentions that Canada's Global Talent Stream program allows companies to hire skilled workers within weeks. In comparison, the U.S. only issues 85,000 H-1B visas each year, and visa processing can take months. As a trade-off, the program encourages but does not require companies to recruit Canadians and permanent citizens before transferring engineers through the Global Talent Stream program. It also mentions 3 separate San Francisco-based startups that have moved tech operations to Canada and the success that they're seeing at a 30 to 40% cost reduction. On July 16th of 2020, in an opinion article written by Laura Huffman for the Houston Chronicle titled, Opinion, Don't Suspend H-1B Visas, Texas Needs Immigrants for Economic Recovery. The key takeaway presented is this, quote, the visa holders targeted by the order are key to job growth. Every H-1B visa holder creates 1.83 American jobs, according to analysis from New American Economy, NAE. This means a 1-year freeze on these visas could result in a loss of 155,550 U.S. jobs. On July 16th of 2020, in a news release, the U.S. Department of State, the Bureau of Consular Affairs, titled Exceptions to Presidential Proclamations 10,014 and 10,052, suspending the entry of immigrants and non-immigrants presenting a risk to United States labor market during the economic recovery following the 2019 novel coronavirus outbreak. Quote, there are certain limited exceptions to this presidential proclamation for humanitarian travel, public health response, and national security. Other limited exceptions may be provided to applicants who are subject to aging out of their current immigrant visa classification before the relevant PPs expire or within 2 weeks thereafter. Certain H and J visa applicants who are traveling to work in support of a critical U.S. foreign policy objective such as COVID-19 response and are traveling at the request of the U.S. government. And then spouses and children of certain visa class holders such as H, J, and L visas who are already accepted from or not subject to PP 10,052. The Department of State will continue to issue H, L, and J visas to otherwise qualified derivative applicants who are otherwise currently accepted or where the principal applicant is currently in the United States. There's no doubt that immigration benefits, immigration reform, H-1B visas and their dependents are making headlines in the news. Do you agree or disagree with any of the articles mentioned today? Leave me a comment below. As mentioned a couple of weeks ago, every other Friday is a Reform It Friday, which is an ongoing short series of recommendations and discussions around H1B visa reform on the H1BGuy.com. So, Reform It number 2. USCIS needs to begin accepting electronic filings for immigration benefits, including H-1B visa. Create a portal that provides access to all of the forms electronically and provide options for uploading and storing evidence documents. USCIS has proven they have the capabilities to accept electronic filings for immigration benefits when they began accepting HCAP submissions for fiscal year 2021. Let's make the process more simple for all parties involved in immigration benefits filings. USCIS should also allow for petitions to be saved in draft mode in order to allow for transparency and review of the individual case. By doing so, it will also allow for USCIS to have even better data collection and document storage on behalf of the petitioner, beneficiary, and USCIS. What do you think about the H-1B Guy's proposal to reform immigration benefits with electronic filings? I want to mention that Monday will be part 3 of the history of the H-1B visa, and to go ahead and block off your calendar, as the H-1B Guy will be doing a live stream here on YouTube, answering any questions you have about H-1B and immigration benefits at 11 a.m. on Wednesday, July the 22nd. As always, please like and subscribe to the H1B Guy, your global source for all things H1B.